in this part 23 of our lecture series. We intend to discuss provisions as far as chapter 7 of the Criminal Procedure Code is concerned, which deals with processes to compel the production of things. During the last part, we dealt with right from section 61 up to section 90 from the point of view of understanding the processes to compel appearance of a person. Now in this part, we shall be discussing processes to compel production of things. Whenever any court or any officer in charge of a police station considers that the production of any document or thing is necessary for the purpose of investigation, inquiry, or the trial, what is the manner in which it can be produced in a court of law, or as far as the officer in charge of a police station is concerned? And the answer to this is by reading the chapter where we shall be dealing with 1. Summons to produce, and 2. Search warrant. When any document or thing is required by officer in charge of a police station, he can issue an order in writing, whereas when the document or thing is required by a court of law, court has got power to issue summons as far as section 91 of the Criminal Procedure Code is concerned. And once this summons is addressed to an individual into whose possession the document or thing is, and then the person need not come to the court of law, but the purpose is served when that document or thing is produced as per the directions which are given by the court of law. When it is required by the officer in charge of the police station, he will issue an order in writing accordingly. So this is summons to produce as far as section 91 of the Criminal Procedure Code is concerned. At times it may happen that a document, parcel or thing is in the possession of the postal or telegraph authority, and under such circumstances section 92 of the Criminal Procedure Code comes into operation, which says when a document, parcel or thing is in the custody of the postal or telegraph authority, the direction or there can be a requisition only on the part of the district magistrate, chief judicial magistrate, court of session or high court. So these authorities can give direction to the postal or telegraph authority to deliver the document as per the directions which are given by these authorities only. When it is needed by any other authority than the which we have already enumerated, namely district magistrate, chief judicial magistrate, court of sessions or the high court, then there can be request to carry out a search with respect to the same and keep it till the order is received from the authorities. So this is as far as section 92 of the Criminal Procedure Code is concerned, which deals with there is a provision to get a document, parcel or thing which is in the custody of postal or telegraph authority, but it is only as per the directions which are given by the authorities. If it is needed, maybe by Commissioner of Police, District Superintendent of Police or Magistrate, for whatever may be the reason, then there must be an order obtained from the authorities as far as section 92 is concerned. Then only you can get those document, parcel or things, otherwise not, as per the provisions of the Criminal Procedure Code. So these this is the power that vests in a court of law to issue summons for the purpose of production of document or thing. If we start reading now, right from section 93 onwards, we come across a provision of what is known as search warrant. As we have learned during course of our learning process, that summons is required to be served, warrant is required to be executed, summons is addressed to an individual, warrant is addressed to the police officer for the purpose of execution. Same is the case as far as the search warrant is concerned. Now, under what circumstances search warrant can be issued as far as this chapter is concerned, and this is a time for me to draw your attention to the fact that there can be a search as per the warrant, for which we shall be dealing with section 93, section 94, section 95 to be read with section 96, section 97 and section 98 of this chapter. But during course of time, when we shall be dealing with different provisions of the Criminal Procedure Code, we will come to know that there can be search in the absence of search warrant also, as far as section 165 of the Criminal Procedure Code is concerned. Now, when we shall be dealing right from section 154 up to section 176 of the Criminal Procedure Code, when we will come to know information to the police and their power to investigate, we will come across a provision as to search without warrant as far as section 165 of the Criminal Procedure Code is concerned. In this chapter, we are dealing with the provisions of search with warrant, and for that when search warrant can be issued by the court of law. If you read section 93, you come across three situations as per which there is a provision to issue a search warrant by the court of law. Where any court has reason to believe that a person to whom a summons or order under section 91 or requisition under subsection 1 of section 92 has been or might be addressed, will not or would not produce the document or thing as required by such summons or requisition, or where such document or thing is not known to the court to be in possession of any person, or lastly, where the court considers that the purpose of any inquiry or trial or other proceedings under this code will be served by general search or inspection, it may issue a search warrant, and the person to whom such warrant is directed may search or inspect in accordance therewith and the provisions hereinafter contained as far as this chapter is concerned. So there are three ways which are enumerated as far as section 93 of the Criminal Procedure Code is concerned, as per which search warrant may be issued by the court of law. Section 94 deals with the cases where search of a place suspected to contain stolen property, forged documents, etc. And it says, if a district magistrate, subdivisional magistrate or magistrate of the first class, upon information and after such inquiry as he thinks necessary, has reason to believe that any place is used for the deposit or sale of stolen property, or for the deposit, sale or production of any objectionable article to which this section applies, or that any such objectionable article is deposited in any place, he may, by order, authorize any police officer above the rank of the constable to carry out search with respect to the same. What do you mean by objectionable article is dealt or is defined as far as this subclause 2 of section 94 of the Criminal Procedure Code is concerned. Now the authority which is given to the person to enter with such assistance as may be required such place, to search the same in the manner specified in the warrant, to take possession of the property or article therein found which he reasonably suspects to be a stolen property or objectionable article to which this section applies, to convey such property or articles before a magistrate, or to guard the same on the spot until the offender is taken before a magistrate, or otherwise to dispose it of in case of safety, to take into custody and carry before a magistrate every person found in such place who appears to have been privy to the deposit, sale or production of any such property or article, knowing or having reasonable cause to suspect it to be stolen property, or as the case may be objectionable article to which this section applies. This is the provision as far as court has got power to issue search warrant as far as section 94 of the Criminal Procedure Code is concerned. With this now, we deal with section 95 of the Criminal Procedure Code, which says power to declare certain publication forfeited and to issue search warrant for the same. When any newspaper or book or any document wherever printed appears to the state government to contain any matter, the publication of which is punishable under section 124A or section 253A or section 153B or section 292 or section 293 or section 295 of the Indian Penal Code, the state government may, by notification stating the grounds of his opinion, declare every copy of issue of such newspaper containing such matter and every copy of such book or other document to be forfeited to the government, and thereupon any police officer may seize the same wherever found in India, and any magistrate may by warrant authorize any police officer not below the rank of sub-inspector to enter upon and search for the same in any premises where any copy of such issue or any such book or other document may be or may be reasonably suspected to be. So this is the manner in which there is a provision whereby a search warrant can be issued by the court of law. In order to understand this section, again time for me to remind you, to refresh your memory. You can understand this section provided you understand the section to which I have referred to as far as Indian Penal Code is concerned. Now, there may be a situation where a person of which book or when a document is declared to be forfeited by the government, he may have objection and he may challenge that it does not fall under section 95 of the Criminal Procedure Code. And hence, when we read section 95 of the Criminal Procedure Code, it is required to be read along with section 96, which says any person having any interest in any newspaper, book or other document in respect of which a declaration of forfeiture has been made under section 95 may, within 2 months from the date of the application in the official gazette of such a declaration, apply to the High Court to set aside such a declaration on the ground that the issue of the newspaper or the book or other document in respect of which the declaration was made did not contain any such matter as is referred to in subsection 1 of section 95 of the Criminal Procedure Code. With this now, there are two more sections as far as the power of the court to issue search warrant is concerned, and those are section 97, which deals with search for persons wrongfully confined, which says, if any district magistrate, subdivisional magistrate or magistrate of the first class has reason to believe that any person is confined under such circumstances that the confinement amounts to an offence, he may issue a search warrant, and the person to whom such warrant is directed may search for the person so confined, and such search shall be made in accordance therewith, and the person, if found, shall immediately be taken before a magistrate, who shall make such order as in the circumstances of the case seems proper. This is to be compared with that of the writ of habeas corpus, with which we deal when we deal with the provisions of the constitutional law. This is with research of a person's wrongfully confined, and this is the time that there can be a search warrant with respect to the person who has been wrongfully confined. With this, section 98 deals with power to compel restoration of abducted females, and it says, upon complaint made on oath of abduction or unlawful detention of a woman or a female child under the age of 18 years or for any unlawful purpose, a district magistrate, subdivisional magistrate or magistrate of the first class may make an order for the immediate restoration of such woman to her liberty, or of such female child to her husband, parent or guardian, or other person having the lawful charge of such child, and may compel compliance with such order using such force as may be necessary. With this now, these are the sections which deal as far as the search warrant is concerned, and then right from section 99 onwards are the sections which deal with when the provisions are dealt up to section 101, which are general provisions relating to searches. And what are these provisions? As you go on reading the provisions, you will come to know that the person who carries out a search must carry out search in presence of independent, respectable inhabitants from that particular locality. If he is not present, then the search is required to be carried out with some other person from some other locality, but otherwise, what is the manner in which search is required to be carried out? If at all you want to enter the premises, and if it is not possible for you to enter the premises without force, there can be a forcible entry by breaking open door or the window, for which you have to refer to section 47 of the Criminal Procedure Code, with which we have dealt when we were dealing with provisions regarding arrests of persons, right from section 41 up to section 60A of the Criminal Procedure Code. Now, this provision, persons in charge of the place must allow search. Then, what is to be done, how the proper disposal of the things found in search is dealt with this chapter, and the power of police officer to seize certain property is dealt as far as the rest of the provisions of this chapter is concerned. If you go through the miscellaneous provisions, What are the reciprocal arrangements relating to processes has been dealt as far as section 105 is concerned. Court has got power to impound document etc. produced is dealt as far as section 104 is concerned, whereas magistrate may direct search in his presence. The procedure in detail regarding search is also dealt as far as this part of the chapter is concerned, and this is as far as processes to compel production of things, right from section 91 up to section 105 of the Criminal Procedure Code.